This is a reviewer on civil procedure, specifically covering rules 5 to 12 on the rules of courts, starting with Rule 5, Uniform Procedures in Trial Courts. Section 1, Uniform Procedure. The procedure in municipal trial courts shall be the same as in regional trial courts, except A, where a particular provision expressly or impliedly applies only to either of said courts, or B, in civil actions governed by the rule on summary procedure. Okay, next, Section 2 of Rule 5, which again, Rule 5 is uniform procedure in trial courts. Section 2 is meaning of terms. The term municipal trial courts, as used in these rules, shall include metropolitan trial courts, municipal trial courts in cities, municipal trial courts, and municipal circuit trial courts. Now I'm going to procedure in regional trial courts, starting with Rule 6, Kinds of Pleadings. Section 1 of Rule 6, Kinds of Pleadings. Pleadings defined. Pleadings are the written statements of the respective claims and defenses of the parties submitted to the court for appropriate judgment. Section 2, Pleadings aloud. The claims of a party are asserted in a complaint, counterclaim, cross-claim, third, fourth, etc., party complaint, or complaint and intervention. Section 2, Paragraph 2. The defenses of a party are alleged in the answer to the pleading asserting a claim against him. Paragraph 3 of Section 2. An answer may be responded to by a reply. Okay, next. Section 3 of Rule 6, Complaint. Rule 6, Section 3, Complaint. The complaint is the pleading alleging the plaintiff's cause or causes of action. The names and residences of the plaintiff and defendant must be stated in the complaint. Rule 6, Section 4, Answer. An answer is a pleading in which a defending party sets forth his defenses. Section 5 of Rule 6, Defenses. Defenses may either be negative or affirmative. Section 5A, a negative defense is the specific denial of the material fact or facts alleged in the pleading of the claimant essential to his cause or causes of action. Section 5B, an affirmative defense is an allegation of a new matter which, while hypothetically admitting the material allegations in the pleading of the claimant, would nevertheless prevent or bar recovery by him. The affirmative defenses include fraud, statute of limitation, release, payment, illegality, statute of frauds, estoppel, former recovery, discharge in bankruptcy, or any other matter by way of confession and avoidance. Section 6 of Rule 6, Counterclaim. A counterclaim is any claim which a defending party may have against an opposing party. Section 7, Compulsory Counterclaim. A compulsory counterclaim is one which, being cognizable by the regular courts of justice, arises out of or is connected with the transaction or occurrence constituting the subject matter of the opposing party's claim, and does not require for its adjudication the presence of third parties of whom the court cannot acquire jurisdiction. Such a counterclaim must be within the jurisdiction of the court, both as to the amount and the nature thereof, except that in original action before the regional trial court, the counterclaim may be considered compulsory regardless of the amount. Section 8, Cross-claim. A cross-claim is any claim by one party against a co-party arising out of the transaction or occurrence that is the subject matter either of the original action or of a counterclaim therein. Such cross-claim may include a claim that the party against whom it is asserted is or may be liable to the cross-claimant for all or part of a claim asserted in the action against the cross-claimant. Section 9, Counterclaims and counter-cross-claims. A counterclaim may be asserted against an original counterclaimant. A cross-claim may also be filed against an original cross-claimant. Section 10, Reply. A reply is a pleading, the office or function of which is to deny or allege facts in denial or avoidance of new matters alleged by way of defense in the answer and thereby join or make issue as to such new matters. If a party does not file such reply, all the new matters alleged in the answer are deemed controverted. Second paragraph of Section 10. If the plaintiff wishes to interpose any claims arising out of the new matters so alleged, such claims shall be set forth in an amended or supplemental complaint. Section 11. Third, fourth, etc. party complaint. A third, fourth, etc. party complaint is a claim that a defending party may, with leave of court, file against a person not party to the action, called the third, fourth, etc. party defendant, for contribution, indemnity, subrogation, or any other relief in respect of his opponent's claim. Section 12 of Rule 6. Bringing new parties. When the presence of parties other than those to the original action is required for the granting of complete relief in the determination of a counterclaim or cross-claim, the court shall order them to be brought in as defendants if jurisdiction over them can be obtained. Lastly, for Rule 6, Section 13, answer to third, fourth, etc. party complaint. A third, fourth, etc. party defendant may allege in his answer his defenses, counterclaims, or cross-claims, including such defenses that the third, fourth, etc. party plaintiff may have against the original plaintiff's claim. In proper cases, he may also assert a counterclaim against the original plaintiff in respect of the latter's claim against the third-party plaintiff. So that's it for Rule 6, which is on kinds of pleadings. Moving now to Rule 7, parts of a pleading. Okay, so moving now to Rule 7, parts of a pleading. Section 1, caption. The caption sets forth the name of the court, the title of the action, and the docket number if assigned. Paragraph 2 of Section 1, the title of the action indicates the names of the parties. They shall all be named in the original complaint or petition, but in subsequent pleadings it shall be sufficient if the name of the first party on each side shall be stated with an appropriate indication when there are other parties. Last paragraph of Section 1, which is paragraph 3, their respective participation in the case shall be indicated. Section 2 of Rule 7, the body. The body of the pleading sets forth its designation, the allegations of the parties' claims or defenses, the reliefs prayed for, and the date of the pleading. Section 2A, paragraphs. The allegations in the body of a pleading shall be divided into paragraphs so numbered as to be readily identified, each of which shall contain a statement of a single set of circumstances, so far as that can be done with convenience. A paragraph may be referred to by its number in all succeeding pleadings. Section 2B, headings. When two or more causes of action are joined, the statement of the first shall be prefaced by the words first cause of action, and the second by second cause of action, and so on for the others. Okay, so Section 2B, which is headings, paragraph 2. When one or more paragraphs in the answer are addressed to one of several causes of action in the complaint, they shall be prefaced by the words answer to the first cause of action or answer to the second cause of action, and so on. And when one or more paragraphs of the answer are addressed to several causes of action, they shall be prefaced by words to that effect. Section 2C, relief. The pleading shall specify the relief sought, but it may add a general prayer for such further or other as may be deemed just or equitable. Section 2D, date. Every pleading shall be dated. Rule 7, Section 3, signature and address. Every pleading must be signed by the party or counsel representing him, stating in either case his address, which should not be a post office box. Section 3, paragraph 2, the signature of counsel constitutes a certificate by him that he has read the pleading, that to the best of his knowledge, the information and belief that there is a good ground to support it, and that it is not interposed for delay. Section 3 of Rule 7, paragraph 3, an unsigned pleading produces no legal effect. However, the court may, in its discretion, allow such deficiency to be remedied if it shall appear that the same was due to mere inadvertence and not intended for delay. Counsel who deliberately files an unsigned pleading or signs a pleading in violation of this rule or alleges scandalous or indecent matter therein or fails to promptly report to the court a change of his address shall be subject to appropriate disciplinary action. Okay, now Section 4 of Rule 7, verification. Except when otherwise specifically required by law or rule, pleadings need not be under oath, verified, or accompanied by affidavit. Paragraph 2 of Section 4, a pleading is verified by an affidavit that the affiant has read the pleading and that the allegations therein are true and correct of his personal knowledge or based on authentic records. Paragraph 3 of Section 4, a pleading required to be verified which contains a verification based on, quotation marks, information and belief or upon, more quotation marks, knowledge, information, or belief, close quotation marks, or lacks a proper verification shall be treated as an unsigned pleading, close quotation marks. This is by the amended Supreme Court Circular 48-00 of August 29, 2000. Next, Section 5 of Rule 7. Certification against forum shopping. The plaintiff or principal party shall certify under oath in the complaint or other initiatory proceeding asserting a claim for relief or in a sworn certification annexed thereto and simultaneously filed therewith, a. that he has not therefore commenced any action or filed any claim involving the same issues in any court, tribunal, or quasi-judicial agency, or, to the best of his knowledge, no such other action or claim is pending therein. B. If there is such other pending action or claim, a complete statement of the present status thereof. And C. If he should thereafter learn that the same or similar action or claim has been filed or is pending, he shall report that fact within 5 days therefrom to the court wherein his aforesaid complaint or initiatory pleading has been filed. Section 5, which is again certification against forum shopping. Paragraph 2 of Rule 7, failure to comply with the foregoing requirements shall not be curable by mere amendment of the complaint or other initiatory pleading, but shall be cause for dismissal of the case without prejudice, unless otherwise provided upon motion and after hearing. The submission of a false certification or non-compliance with any of the undertakings therein shall constitute indirect contempt of court without prejudice to the corresponding administrative and criminal sanctions. If the acts of the party or his counsel clearly constitute willful and deliberate forum shopping, the same shall be ground for summary dismissal with prejudice and shall constitute direct contempt as well as cause for administrative sanctions. So that's it for Rule 7, parts of a pleading. Moving now to Rule 8, manner of making allegations in a pleading. Section 1 of Rule 8, in general, every pleading shall contain in a methodical and logical form a plain, concise, and direct statement of the ultimate facts on which the party pleading relies for his claim or defense, as the case may be, omitting the statement of mere evidentiary facts. Paragraph 2 of Section 1 of Rule 8. If a defense relied on is based on law, the pertinent provisions thereof and their applicability to him shall be clearly and concisely stated. Okay, Section 2 of Rule 8. And again, Rule 8 is manner of making allegations in pleadings. Section 2, alternative causes of action or defenses. A party may set forth two or more statements of a claim or defense, alternatively or hypothetically, either in one cause of action or defense or in separate causes of action or defenses. When two or more statements are made in the alternative and one of them is made independently, and this would be sufficient, the pleading is not made insufficient by the insufficiency of one or more of the alternative statements. Section 3 of Rule 8, conditions precedent. In any pleading, a general averment of the performance or occurrence of all conditions precedent shall be sufficient. Section 4, capacity. Fact showing the capacity of a party to sue or be sued by the authority or by the authority of a party to sue or be sued in a representative capacity, or the legal existence of an organized association of persons that is made a party must be averred. A party desiring to raise an issue as to the legal existence of any party or the capacity shall do so by specific denial and shall include such supporting particulars as are particularly within the pleader's knowledge. Section 5 of Rule 8. Fraud, mistake, condition of the mind. In all averments of fraud or mistake, the circumstances constituting fraud or mistake must be stated with particularity. Malice, intent, knowledge, or other condition of the mind of a person may be averred generally. Section 6. Judgment. In pleading a judgment or decision of a domestic or foreign court, judicial or quasi-judicial tribunal, or of a border officer, it is sufficient to aver the judgment or decision without setting forth matter showing jurisdiction to render it. Section 7 of Rule 8. Action or defense based on document. Whenever an action or defense is based upon a written instrument or document, the substance of such instrument or document shall be set forth in the pleading, and the original or a copy thereof shall be attached to the pleading as an exhibit, which shall be deemed to be part of the pleading, or said copy may with like effect be set forth in the pleading. Section 8 of Rule 8. How to contest such documents. When an action or defense is founded upon a written instrument, copied in or attached to the corresponding pleading as provided in the preceding section, the genuineness and due execution of the instrument shall be deemed admitted unless the adverse party, under oath, specifically denies them and sets forth what he claims to be the facts. But the requirement of an oath does not apply when the adverse party does not appear to be a party to the instrument, or when compliance with an order for an inspection of the original instrument is refused. Section 9. Official document or act. In a pleading, official document or act. Section 9. In pleading an official document or official act, it is sufficient to aver that the document was issued or the act done in compliance with law. Section 10. Specific denial. A defendant must specify each material allegation of fact, the truth of which he does not admit, and whenever practicable, set forth the substance of the matters upon which he relies upon to support his denial. Where a defendant desires to deny only a part of an averment, he shall specify so much of it as is true and material, and shall deny only the remainder. Where the defendant is without knowledge or information sufficient to form a belief as to the truth of a material averment made in the complaint, he shall so state, and this shall have the effect of a denial. Whew, that section just gave me tongue twisters. Section 10. Specific denial. Let's go through it again. A defendant must specify each material allegation of fact, the truth of which he does not admit, and whenever practicable, shall set forth the substance of the matters upon which he relies upon to support his denial. Period. Where a defendant desires to deny only a part of the averment, he shall specify so much of it as is true and material, and shall deny only the remainder. Period. Where the defendant is without knowledge or information sufficient to form a belief as to the truth of a material averment made in the complaint, he shall so state, and this shall have the effect of a denial. Period. Okay, gets. Section 11 of Rule 8. Allegations not specifically denied deemed admitted. Material averments in the complaint, other than those as to the amount of unliquidated damages, shall be deemed admitted when not specifically denied. Allegations of usury in a complaint to recover usurious interest are deemed admitted if not denied under oath. So that's Section 11, allegations not specifically denied, deemed admitted. Lastly, under Rule 8, Section 12, striking out of a pleading or matter contained therein. Upon motion made by a party before responding to a pleading, or if no responsive pleading is permitted by these rules, upon motion by a party within 20 days after the service of the pleading upon him, or upon the court's own initiative at any time, the court may order any pleading to be stricken out, or that any sham or false, redundant, immaterial, impertinent, or scandalous matter be stricken out therefrom. So that's it for Rule 8, which covers manner of making allegations in pleadings. Moving now to Rule 9, the effect of failure to plead. Section 1 of Rule 9. Defenses and objections not pleaded. Defenses and objections not pleaded. Defenses and objections not pleaded either in a motion to dismiss or in the answer are deemed waived. However, when it appears from the pleadings or the evidence on record that the court has no jurisdiction over the subject matter, that there is another action pending between the same parties for the same cause, or that the action is barred by prior judgment or by the statute of limitations, the court shall dismiss the claims. That's Section 1. Section 2 for Rule 9, compulsory counterclaim or cross-claim not set up barred. A compulsory counterclaim or cross-claim not set up shall be barred. Section 3, default declaration of. If the defending party fails to answer within the time allowed therefore, the court shall, upon motion of the claiming party with notice to the defending party, and proof of such failure, declare the defending party in default. Thereupon, the court shall proceed to render judgment, granting the claimant such relief as the pleading party may warrant, unless the court, in its discretion, requires the claimant to submit evidence. Such reception of evidence may be delegated to the clerk of court. Section 3A, effect of order of default. A party in default shall be entitled to notice of subsequent proceedings, but not to take part in the trial. Section 3B of Rule 9, relief from order of default. A party declared in default may at any time after notice thereof and before judgment file a motion under oath to set aside the order of default upon proper showing that his failure to answer was due to fraud, accident, mistake, or excusable negligence, and that he has a meritorious defense. In such case, the order of default may be set aside on such terms and conditions as the judge may impose in the interest of justice. Section 3 of Rule 9, C, effect of partial default. When a pleading asserting a claim states a common cause of action against several defending parties, some of whom answer and the others fail to do so, the court shall try the case against all upon the answers thus filed and render judgment against the evidence presented. Section 3D, extent of relief to be awarded. A judgment rendered against the party in default shall not exceed the amount or be different in kind from that paid for nor awarded unliquidated damages. Lastly, Section 3 for Rule 9, which is again effective failure to plead. And Section 3 talks about default, declaration thereof. Last one, E, where no defaults allowed. If the defending party in an action for annulment or declaration of nullity of marriage or for legal separation fails to answer, the court shall order the prosecuting attorney to investigate whether or not a collusion between the parties exists, and if there is no collusion, to intervene for the state in order to see to it that the evidence submitted is not fabricated. So that's it for Rule 9. Moving now to Rule 10, Amended and Supplemental Pleadings. Rule 10, Amended and Supplemental Pleadings. Section 1 of Rule 10, Amendments in general. Pleadings may be amended by adding or striking out an allegation or the name of any party, or by correcting a mistake in the name of a party or a mistaken or inadequate allegation or description in any other respect, so that the actual merits of the controversy may speedily be determined without regard to technicalities or in the most expeditious and inexpensive manner. Section 2 of Rule 10, Amendments as a matter of right. A party may amend his pleading once as a matter of right at any time before a responsive pleading is served, or in the case of a reply, at any time within 10 days after it is served. Section 3, Amendments by leave of court. Except as provided in the next preceding section, substantial amendments may be made only upon leave of court, but such leave may be refused if it appears to the court that the motion was made with the intent to delay. Orders of the court upon the matters provided in this section shall be made upon motion filed in the court, and after notice to the adverse party and an opportunity to be heard. Section 4, Formal Amendments. A defect in the designation of the parties and other clearly clerical or typographical errors may be summarily corrected by the court at any stage of the action. as its initiative or on motion, provided no prejudice is caused thereby to the adverse party. Section 5 of Rule 10, amendment to conform to or authorize presentation of evidence. When issues not raised by the pleadings are tried with the express or implied consent of the parties, they shall be treated in all respects as if they had been raised in the pleadings. Such amendment to the pleadings shall, as may be necessary to cause them to conform to the evidence and to raise these issues, may be made upon motion of any party at any time, even after judgment. But failure to amend does not affect the result of the trial of these issues. If evidence is objected to at the trial on the ground that it is not within the issues made by the pleadings, the court may allow the pleadings to be amended and shall do so with liberality if the presentation of the merits of the action and the ends of substantial justice will be subserved thereby. The court may grant a continuance to enable the amendments to be made. So that's Section 5 of Rule 10. Section 6, Supplemental Pleadings. Upon motion of a party, the court may, upon reasonable notice and upon such terms as are just, permit him to serve a supplemental pleading setting forth transactions, occurrences, or events which have happened since the date of the pleading sought to be supplemented. The adverse party may plead thereto within 10 days from notice of the order admitting the supplemental proceeding. The supplemental pleading. My bad. Section 7. Filing of amended pleadings. When any pleading is amended, a new copy of the entire pleading incorporating the amendments, which shall be indicated by appropriate marks, shall be filed. Lastly, for Rule 10, Section 8, Effect of amended pleadings. An amended pleading supersedes the pleading that it amends. However, admissions in superseded pleadings may be received in evidence against the pleader, and claims or defenses alleged therein not incorporated in the amended pleading shall be deemed waived. So that's it for Rule 10, which covers amended and supplemental pleadings. Okay, now moving to Rule 11. When to file responsive pleadings. Section 1, Answer to the complaint. The defendant shall file his answer to the complaint within 15 days after service of summons unless a different period is fixed by the court. Section 2 of Rule 11, Answer of a defendant, foreign private juridical entity. Where the defendant is a foreign private juridical entity and the service of summons is made on the government official designated by law to receive the same, the answer shall be filed within 30 days after receipt of summons by such entity. Section 3. Answer to amended complaint. Where the plaintiff files an amended complaint as a matter of right, the defendant shall answer the same within 15 days after being served a copy thereof. Paragraph 2 of Section 3 of Rule 11. Where its filing is not a matter of right, the defendant shall answer the amended complaint within 10 days from the notice of the order of admitting the same. An answer earlier filed may serve as the answer to the amended complaint if no new answer is filed. Third paragraph of Section 3 of Rule 11. This rule shall apply to the answer of an amended counterclaim, amended cross-claim, amended third, fourth, etc. party complaint, and amended complaint and intervention. Section 4 of Rule 11. Answer to counterclaim or cross-claim. A counterclaim or cross-claim must be answered within 10 days from service. Section 5. Answer to a third, fourth, etc. party complaint. The time to answer a third, fourth, etc. party complaint shall be governed by the same rule as the answer to the complaint. Section 6. Reply. A reply may be filed within 10 days from the service of the pleading responded to. Section 7. Answer to supplemental complaint. A supplemental complaint may be answered within 10 days from the notice of the order admitting the same unless a different period is fixed by the court. The answer to the complaint shall serve as the answer to the supplemental complaint if no new or supplemental answer is filed. Section 8. Existing counterclaim or cross-claim. A compulsory counterclaim or cross-claim of a that a defending party has at the time he files his answer shall be contained therein. Sorry, let me say that again. Section 8. Existing counterclaim or cross-claim. A compulsory counterclaim or cross-claim that a defending party has at the time he files his answer shall be contained therein. Section 9 of Rule 11, counterclaim or cross-claim arising after answer. A counterclaim or cross-claim which has either matured or was acquired by a party after serving his pleading may, with the permission of the court, be presented as a counterclaim or a cross-claim by supplemental proceeding before judgment. Section 10. Omitted counterclaim or cross-claim. When a pleader fails to set up a counterclaim or cross-claim through oversight, inadvertence, or excusable neglect, or when justice requires, he may, by leave of court, set up the counterclaim or cross-claim by amendment before judgment. Section 11. Extension of time to plead. Upon motion and on such terms as may be just, the court may extend the time to plead provided in these rules. Section 11, paragraph 2. The court may also, upon like terms, allow an answer or other pleadings to be filed after the time fixed by these rules. So that's it for Rule 11, when to file responsive pleadings. Okay, last one for this one, Rule 12, Bill of Particulars. Section 1. When applied for purpose. Before responding to a pleading, a party may move for a definite statement or for a bill of particulars of any matter which is not averred with sufficient definiteness or particularity to enable him properly to prepare his responsive pleading. If the pleading is a reply, the motion must be filed within 10 days from service thereof. Such motion shall point out the defects complained of, the paragraphs wherein they are contained, and the details desired. Section 2. Action by the court. Upon the filing of the motion, the clerk of court must immediately bring it to the attention of the court, which may either deny or grant it outright, or allow the parties the opportunity to be heard. Section 3. Compliance with order. If the motion is granted either in whole or in part, the compliance therewith must be effected within 10 days from the notice of the order, unless a different period is fixed by the court. The bill of particulars or a more definite statement ordered by the court may be filed either in a separate or in an amended The bill of particulars or a more definite statement ordered by the court may be filed either in a separate or in an amended pleading, serving a copy thereof on the adverse party. Section 4 of Rule 12. Effect of non-compliance. If the order is not obeyed or in case of insufficient compliance therewith, the court may order the striking out of the pleading or the portions thereof to which the order was directed, or make such other order as it deems just. Section 5. Stay of period to file responsive pleading. After service of the bill of particulars or of a more definite pleading, or after notice of denial of his motion, the moving party may file his responsive pleading within the period to which he was entitled at the time of filing of his motion, which shall not be less than 5 days in any event. Lastly, for Rule 12, Section 6, Bill a part of pleading. A bill of particulars becomes a part of the pleading for which it was intended. So that's it for Rule 12, Bill of Particulars. Rule 11, when to file responsive pleadings. Rule 10, Amended and Supplemental Pleadings. Rule 9, effect of failure to plead. Rule 8, manner of making allegations in pleadings. Rule 7, parts of a pleading. And Rule 6, kinds of pleading. And this is all under procedure in regional trial courts. We also covered Rule 5, uniform procedure in trial courts.